everybody. Welcome to this free workshop. I'm going to actually just go full screen for a minute with me. My name is Maureen McManus. I am the founder and creator of BarMD. So thank you so much for joining me tonight for this free MBE workshop. I'm super excited to have you all here. We're going to cover a lot. I'm going to try to keep it on the shorter end. I know I blocked like a 2-hour session because I kind of like to go deep into everything, but I'm going to try to keep it on the shorter side of that, so closer to an hour, hopefully. So just wanted to quickly introduce myself. I've been doing bar prep for, God, like almost 10 years now. I have done everything for the bar, for the UBE and for California and other jurisdictions as well. So if you're taking Nevada or Georgia or somebody that doesn't do the exact UBE style, but still need help, you can feel free to reach out and we can talk about your scores, etc. I'm just curious, for those of you here, can you tell me what jurisdiction you're taking? Can you just put it in the chat real quick, just so I can see, get an idea of where everybody is? So big mix, a lot of California. I know California results come out in a few weeks. I know for UBE, most results are pretty much out. If anybody, if you haven't had a one-on-one session with me yet, you can book a free score review with me. So in that, what we'll do is you will have like a 20-minute session where I'm going to go over your scores with you. I'm going to look at your score sheet. If you have your essays, have your PTs, I'm going to look at those with you, show you, what specifically you needed to do better. So you can use, I'm going to put the link in the chat. So if you want to schedule a time to meet with me, you can use that link. It's just limited to one. So if you haven't gotten your scores yet, wait to book that. If you have gotten your scores though, like I've been meeting with the people in a bunch of different UBE jurisdictions recently, you can definitely use that, schedule an appointment. I'm happy to chat with you. Hopefully you don't need to do that. Hopefully if you're waiting for results, like I know all you California folks are, hopefully you can just if you took it for July, you can just celebrate. If you want to meet with me, I honestly don't always need to look at your essays and PTs. I know what the scores mean. So I know if you get a 2 or a 3, really what that means. But if you do want if something throws you off, you're like, I don't understand how I got a 2 on this essay, then I do want to have your essays. And so that way we can do a deeper dive into your actual documents. But I can help you understand what the scores mean. We can talk about a strategy for you, particularly what does that look like with, your everything going on in your life? What should you be doing? All of that sort of stuff. It's not a tutoring session, so I'm not going to answer questions on a bunch of black letter law and all of that stuff, but I'm happy to just sort of strategize with you. I also just want to do a plug at the outset. I have 3 books coming out very soon. So they start coming out November 10th. So the first book that I'm super, super excited about, I'll talk about it at the end too, and I'll show you guys a little preview of it. I had to sort of edit some stuff out of it though for this because I can't share any licensed materials. But I have an MBE book. So for anybody that had a hard time with the MBEs, I'm super excited about this book that is coming out. It's going to be all the black letter law that you need, plus strategies, tips, etc., plus 410 questions, all put together as assignments so that it can really be a course of study for the MBE. So we'll incorporate that with your adaptive art or UWorld or whatever it is that you have, so that you're not just kind of blindly going in and doing questions every day. I'm going to really go in and say okay, you're going to start with the book. You start with that. And then how do you go from there once you've gone through the whole book? So it's really I think most people need structure, and that most people need structure. So it's really incredibly helpful. So I wanted to sort of provide that with the book along with questions. I'm going to show you a preview of the book tonight. And yes, the sample will be out. I'm releasing a portion of the Civ Pro book in the next day or 2. So it won't have the questions in it. So I have to retract those just because to do a free sample, I can't include real questions. Otherwise I have to pay a large licensing fee. So those won't be included, but you'll get a sense of how the black letter law is laid out. So, and there's chapters beyond just what I'm going to release. Obviously there's a chapter for every subject, or there's, a section for each subject. Plus there's stuff at the beginning, just addressing the MBE, talking about overall strategy, MBE tips broadly. And then we get into the actual assignments. The MBE book will be available. It'll be on the website on November 10th. That's when it will be on the website, and it'll be digital to start. And then within about 3 weeks, the hard copy books will start to ship as well. So you can opt to just have it digitally, or you can add on just for the cost of the printing and shipping. You can add on and also get the hard copy, which I think a lot of people will want. And for those of you that do want that, are waiting for the hard copy, we're going to make part of the book actually printable for you as well. So a lot to kind of coordinate there. So that's why it's coming out November 10th, is because there is just a lot to coordinate. And I also lost quite a lot of the book about 10 days ago. So I've been trying to recover that when a computer died. So which wasn't very fun. But that all being said, and I also have a really exciting new MBE course that we have on promo that's going to be only on promo until the end of this month. And it's a really, really good deal. So you'll want to sign up for that too if you're having a little bit of a harder time with the MBE or if you struggle with that, because it's only $99 for an MBE course, including 200 questions, and it's 8 sessions. So it's a lot of detail, a lot of tips and strategy stuff. So, and it's going to be a really nice complement to the book. So I'm really, really excited about that too. So let's get into it. So today's objectives, I want to talk about how to approach MBEs. This is just sort of broad. It's broad. In the classes that we do, I will walk you through the approach and how to really dissect. Because when I talk to people that are studying, people don't go, in my opinion, do not go in deeply enough into each MBE. So I like to really demonstrate how I want you to be digging into questions. So that's a big thing for me. One thing that I think really sets BarMD apart from any other bar prep company is we really show you how to do things. We don't just tell you what to do. We don't just give you a bunch of information and throw a bunch of lectures at you. I really care about you, and understanding how to do anything. So I am not scared of any component of the bar. I want to literally walk you through it. And I also always want to approach it from the person. I work with a lot of foreign attorneys. And so a lot of people that, maybe just done an LLM, haven't done a JD in the US. So I'm always trying to meet at least a person at that level. So, it should be I try to make it as easy to understand as possible. So that's my approach. So, there's a typo there. I copied the wrong thing. Understand how to approach MBEs, understand the heavy hitter categories. And it should have said, understand some tips for each subject. I must not have copied that right. So I'm going to give you just a few tips for each of the subjects as well today. So just as a brief overview, these are all of the 7 subjects that are tested. I always have people start with civil procedure when they're studying with me because there's civil procedure overlap in the other subjects, particularly torts, contracts, and some property. Civ Pro, Common Law, contracts also obviously covers the UCC and also covers it also covers remedies. So there's contract remedies and torts remedies tested. So there is remedies tested within those 2 subjects as well. You have criminal law and procedure. You have evidence, which is just the federal rules of evidence, obviously. You have real property, but also within real properties, one thing that throws a lot of people off is there are some questions. One of the components of property is the transfer of property by will. So there's also some wills issues that are within property, and that throws people off quite a bit. So there's a little bit of crossover there. And then again, like I said, there's remedies tested within torts. You have 25 questions in each subject, 25 questions per subject, 25 experimental questions. You cannot tell the difference, so don't try. And a really important thing is to actually understand there is this document that's the MBE subject matter outline. I'm going to pull it up and put a link. I'm going to put a link in the chat. There's also one for the MEE. It's this document is what I'm referring to. So I'll put the link in the chat right now. So this document is something you really want to be familiar with. You should have it as a guide. I keep it printed when I'm writing material, and I keep it when I'm tutoring. I do a ton of tutoring for the MBE. And I'm trying to move away from tutoring. That's why I'm writing the books, because I'm hoping to make it less expensive and more accessible for people to get all the knowledge that I have, I think, to share that I've learned from tutoring, I don't know, thousands of students over the last 10 years on this stuff. Yes, 25 questions per subject for all of the MBEs. So 200 questions, 100 questions in the morning, 100 questions in the afternoon. And yeah, it's 25 per subject and then 25 experimental. So this is what I call heavy hitter categories, which I'm going to get into in depth, but you should really be familiar with all of the various topics within each subject. So Civ Pro, there's I think 7 categories. So that are all, here with Roman numerals, and you need to know what each category consists of. So that's really important. So I really encourage everybody to print this document out, really get to know it, just so that you can mark it up. And it's helpful just to have it handy to always be referencing this document when you're really trying to identify where your strengths and weaknesses are. So this document's incredibly, incredibly helpful, and I think really important and often overlooked by people. So there's all the 7 subjects. Get familiar with what are the topics tested within each subject as well, and how they break it down. And my book, the MBE book, will have all of the black letter law for all of these topics keyed to this document, because most people use either Adaptive Bar or excuse me, or UWorld for studying. And those programs both, yeah, UWorld does too. Themis and some bar prep programs don't key it to this, but I think it's really helpful to be keyed to this document because you want to know how many questions within each topic you're going to get. So like of the heavy hitters, you really want to be able to focus in on those and know what that consists of. So yeah, 200 questions, 175 graded, 25 experimental, 25 questions from each subject area. Really, really important too at first. Well, I'll get into that in a minute actually. So, but just general format stuff here. And then what do the MBE questions test? So they'd really test three things. They test three things. So they obviously test your law knowledge, your rule of law. They test your application. Most people know that. And that's really what the MBE questions do. It's not just asking you a question on the black letter law. Like, you know, maybe when we were growing up, if you grew up doing multiple choice questions, then we're used to that. We're just used to like a knowledge question. Whereas with the MBE questions, it's really an application of the law to the given set of facts. So that's what makes these questions difficult, because not only that, but it's really, they really are trying to trick you. They're trying to trip you up as you do it. So you have to really understand how to dissect MBE questions and really how to pull them apart. They also test your reading comp. And I would say about 20% of the questions that people miss, in my experience, is based on reading comprehension. So, and it's not just like, oh, you didn't understand a word. That's not what I mean. It can be that, but it's skipping over a word, not understanding what a particular fact was in the fact pattern to trigger, like not understanding, oh, when I see that word, it means that I have to think this issue, or that that's the impact of this issue. So you have to really get good and really criticize and understand when you miss a question, did you just not know the law? Or was it something else? Did you, are you skipping over words? Are you reading too quickly? And then, when you identify what that issue is, how do you resolve that? So that's all very important. And this is often what I'm figuring out. Most people think it's the law knowledge, but it's not. Like when you see a question and you're like, God, I know that rule. Why did I miss it? It's the way that the question is phrased. And so you have to figure out what is it about that question that made you miss it. And in that MBE minutia class that we're starting at the end of November, I'm going to like really dig into that for each subject. So this is just broadly how to approach MBEs. So just very broadly in the classes, I will like actually walk through this quite a bit. But the first thing you do is you always read the call to question, right? So you read the call to question because often it will point you in a particular direction. Like in a lot of con law questions, I don't even have to read the fact pattern. I mean, I wouldn't advise you to do that, but often I know, like I read the call to question, I'm like, okay, this is really what they're asking. And then I read the fact pattern, I'm like, yeah, it was this exact thing that I thought, but I would never suggest that you actually do skip the fact pattern. So you read the call, think about, if you can, identify the issue, like what's in controversy. Every single MBE just has one little thing going on. They're going to try to like walk you towards 3 or 4 different things, but it's just one little thing that they're trying to get at. So you have to know when they're using a distractor fact and when they're actually like walking you towards a particular answer. So that's what trips people up. That's why you get stuck between 2 answers, because there's almost always going to be 2 attractive answers, and you have to be able to really differentiate between the 2 and know what is a better answer between the 2. So read the call to question, then go through the fact pattern, identify the issue and controversy, and then also identify what's the relevant rule. Then you want to go through a process of elimination of the 4. So identify the issue and controversy and the relevant rule, then say, okay, I think the answer should be something involving X, right? So you try to predict the answer, you hear that, but how do you do that, right? So you're trying to say like, okay, this is, I'm dealing with this particular issue. And often the incorrect answer choice is going to deal with another issue that's actually just a total distractor. Or it's going to be, you'll have like a rule and an exception to the rule, and you have to figure out what's better between the 2 and why. So identify the issue and controversy, what's the relevant rule, try to predict the answer, but then go through, look for the answer that you were looking for, but also go through the other 3 answers. And before you look, this is when you're practicing. Before you look at the answers, can you write out what is wrong with A, what is wrong with B, what is wrong with C, and then why is D correct? And it's really important that you do that, because if you can't explain why an answer choice is incorrect, then there's something about the law on that issue that you probably don't know deeply enough. So many questions can be, so oftentimes they'll give you a rule that doesn't apply. Well, why doesn't that rule apply? So you want to identify that. Okay, this one misstates the law because it states that the relevant standard is X when the relevant standard is Y. So you want to really get good at eliminating answer options. And this takes a little bit of time. It takes longer to do MBE questions this way, but this will really help you to get very good at doing the MBEs. And in my book, I go through this. I give you a template, a form to fill out. Also in the class, I give you this stuff too. And then after you have like really dissected the 4 answer choices, and sometimes you're just like, I know A is incorrect, but I don't know why. So then you want to really figure that out. You have to make a note of that. I don't want you to just ever just like sit there and struggle and be like, oh, I don't know, like, and try to like look up the law and all of that. No, if you're not sure why A is incorrect, just say that, not sure. And then it tells you you need to go deeper on that answer choice. And you have to really dig in and ask yourself, when you compare what you wrote or what you didn't know to the correct answer and the incorrect answers and the explanations, you need to really get at you need to really understand pulling apart those answer options, like what really is wrong with that. Somebody asked me when the book is being released. It's November 10th is the release date. November 10th is the release date. That will be done. It'll be on our website. We'll send out an email, etc. So I'm super excited. And the MBE class you can sign up for, and you should sign up for as soon as possible, just because the price is going to go up at the end of this month. Okay, I'm going to talk about heavy hitter categories. So going back to this MBE subject matter outline, going back to this. So it tells you at the top of each subject, there's, 1/3 of the questions are going to be here, 1/3 here, and 1/3 here. So you want to pay attention to this. And it's really important because when you are doing, and I'm going to show you all this in a minute. I have one of my students said that I could share her adaptive bar screen. So I'm going to go ahead and show that and share screen with everybody. So like Civ Pro, the categories that you need to know really, really well, because I think about 18 of your questions are going to be on jurisdiction and venue, pretrial procedures, and motions. So those 3 topics, that covers a ton of information. And you want to know, okay, if you're not doing well in jurisdiction and venue, where is it that you're not doing well? So for example, do you keep getting supplemental jurisdiction questions wrong? Because you don't just want to say okay, I got 50% correct and I'm just not good at jurisdiction and venue. You want to really dig in and look at that data. You want to look at the questions and really pull them apart to understand why you're missing particular questions and what is it. So for example, somebody the other day I was looking at, they kept missing questions on removal. And it's really they didn't understand. They kept picking an answer that said, if it said was removal proper, they would say yes, because there's subject matter jurisdiction, but they weren't thinking about all the technicalities. The removal wasn't proper because the wrong party removed it. So they were focused on because one of the things that they say, and this is in the book, is when they say it was removal proper, that generally means that SMJ is that there is SMJ plus all of those little technical rules. So you really want to think about that. Look at the way the question is phrased. They kept missing that. And it was always that it was a technical requirement that was missing or that was incorrect. So, or they removed it, say the original suit was filed in state court, and they removed it to state B, right? You can't do that. You have to remove it to the federal court that embraces the court, the case that embraces the court where the case was originally filed. So it's really getting at all those little tiny nitty gritty details, but understanding the way the question is just phrased, what they're actually looking for. So that starts with getting an understanding of, okay, I'm doing these questions. And in my book, I start you off with the black letter law. I give you assignments, just testing you on jurisdiction and venue. And then after that, you go in and you would incorporate your UWorld, your adaptive bar, either way, and really start doing questions and digging into your jurisdiction venue, digging into your pretrial procedures, because you can do targeted questions within these topics, but you really want to be able to dig in. So with motions, right? Is it particular motions that are tripping you up? It's also the interplay of the various motions. So, knowing that, for example, what is a JMOL and an RJMOL actually testing, right? Those are testing the sufficiency of the evidence, right? So if you know that they're testing the sufficiency of the evidence, you cannot file an appeal challenging the sufficiency of the evidence when you haven't done a JMOL and an RJMOL. But a lot of people see appeal, yep, I can appeal this issue, but you can't. And that's not stated anywhere in the rules. You have to know that by doing questions and looking at the interplay of all of the various rules. So a lot of it, all of these little things that I'm mentioning about the black letter law, those are all in the book. And I'm going to cover some of this stuff in the class too. The class is going to be focused more on really dissecting questions and showing you how these things work. But so you really want to do a deep dive into I do have some tips on motions later. Somebody asked in the chat, in the Q&A. I do have a table for motions a little bit later. So these are your heavy hitter categories, but be familiar with this document and know what within pretrial procedures, what is that, right? It's a huge mix of stuff that doesn't necessarily seem totally congruent. So you want to just really be familiar with that. Contracts, formation and perform 2/3 of the questions in contracts are formation and performance breach and discharge, which makes sense, right? But like some people I see, they'll do a ton of questions. They'll be like, oh, I suck at third-party beneficiaries. But you're going to get like 2 questions on that. So fine. Right. So I wouldn't spend a ton of time on third-party bennies. Like I remember that was something that I spent a ton of time on when I prepped for the bar. And then like, but nobody told me like, Maureen, you're only going to get like a couple of questions on that. Don't worry about it. And it doesn't really come up on the essays too much. And when it does come up on the essays, it's pretty straightforward. You don't get these really complicated questions. So, and like with information, do you constantly miss, like one of the things that I walk through is identifying, like in the course, is really getting, and it's in the book too, is really identifying the point of formation. And like if you don't do that, so like how do you really go about doing contract problems? Like, making a little timeline, diagramming stuff out quickly and efficiently. So you really do have to be able to do that stuff. But formation, performance breach, and discharge. And like a huge thing with contracts that I'm going to get to in a second is also like, is knowing like where are there major discrepancies within UCC and common law. So you want to have a list of that. And like, you always want to start off with a contract problem, like make a note, is it UCC or common law? If it's UCC, are there merchants involved? So keep that stuff in mind. So I'm going to get through the tips later. I really just want to focus on the heavy hitters. Common law, half the questions are on individual rights. So you really want to be good at your individual rights, then half. So you're going to get like 12, 13 questions on individual rights. And then there's 3 other categories within common law. There's nature of judicial review, separation of powers, and relation of nation and states in a federal system. So you're going to have 4 questions from each in those first 4 categories, and then 12 or 13 on individual rights. So you really want to dig in and like, because the thing is like, you don't just want to do a ton of individual rights. You want to know, is there freedom of speech issues, etc. Torts, half the questions are negligence, and then the other half is from the other categories. So you want to be, and the thing is usually with individual rights, people miss stuff within the same things. And like the way that they test, so you have to really know the standards. I have a table of all the standards and like free speech and all of that in the book. But a lot of times people get tripped up because they don't think that there'll be a question and the answer is either like equal protection or substantive due process, and it's not really obvious. Or you'll say like, well, there's no fundamental right and there's no discrimination based on a group here, or the group is not a protected group, so there's not a violation, but it's the only, so it would be rational basis review, the only argument that could possibly win. So though that answer is correct, even though it's probably a losing argument. So your individual rights. And Montserrat, I know you raised your hand, but I'll get to questions at the end, so if you can just hold off on that. Richard. Sorry, but my doggy. All right, evidence. Evidence is fairly evenly split. But there is a bit of a lean on relevance, presentation of evidence, and hearsay. My dog wants to join us. So you want to really be familiar with those 3 topics. And these are also where people have a tougher time. So with relevance, there's also character evidence involved in there. Presentation. Oh, okay. Thanks. Presentation of evidence. There's a bunch of different random issues in here, but people generally tend to miss the same issues within these topics. Impeachment, contradiction is presentation of evidence. So that's usually what people are missing within evidence or within presentation of evidence. With relevance, it's a lot of, it's character evidence. So it's just really those questions. So you want to know, okay, like identify that and like really be very targeted and very intentional with your review, not just doing tons and tons and tons of questions. And I'm going to talk about that in a minute, because I hear people say like, oh, you have to do 4,000 questions. That is not true. Maybe for some people that's really what's necessary, but it is generally speaking not the case. And I wouldn't suggest just doing that. Hopefully my doggy will calm down now. Property, there are, is it 5 topics? I think it's 5, and all of them are equal. So 5, it's all equal. There's 5 topics and they're all equal. Which means the really important thing is what people tend to miss the most questions in is ownership, I would say, within property. And ownership has probably all of the most difficult issues within it. So that's like your present estates, your future interest, RAP, landlord. Well, there's like, special problems. There's like fair housing discrimination, conflict of law. There's all sorts of stuff in that category, but you have all the future interest and RAP there. So that means you're going to maybe get, RAP is tested. RAP is definitely tested. You're going to maybe get like 2 questions tested, because there's so many issues under ownership that you're going to maybe get 1 or 2 questions on future interest. So that's something that people have a really hard time with, though. So it just means that you generally don't need to spend, like, don't do an entire day just on future interest. So really know how to manage your time, how to strategize for yourself as an individual. That's super, super important. So yeah. And then with crim, it's equally split between crim and crim pro. So you're gonna have 12 or 13 of each. And again, like always really focus in on, okay, if it's within Crim Pro, where is it? And Crim is broken down a little bit more. So it's broken down into homicide, inchoate crimes, and then general principles and other crimes. So there's 4 categories of Crim, and then all of Crim Pro is one topic, and they don't break it down, which is, I think, really annoying. Good to know. So you want it like Crim Pro, you really have to sort of like pull apart a bit on your own to figure out where your strengths and weaknesses are. Any questions so far? Anybody want to put in the chat? Yeah, future just come up on the MBE. They definitely do come up there, but they're not as complicated usually. Because I have an MBE book coming out. I've literally gone through every single MBE that is available. And I have like rules and outlines and templates for how to analyze any issue that's been tested on the MBE, literally. Yeah, but they do come up in RAP. RAP has been tested particularly recently. It's been tested like 3 times on the essays, but it's not usually crazy complicated. Whereas in that you have like a whole essay to deal with versus, a single MBE where you have not as much time and you have to really go through and do a bunch of analysis for that one MBE. So, and the thing is with RAP on the MBE, like I am not of the opinion that you don't need to know RAP. Like I am not of that opinion for UBE people because it can come up and has come up on the essays. You do need to be familiar with that stuff 100%. RAP doesn't come up in California essays. It hasn't come up historically. But what you do need to know, what is important though, is if you are a UBE taker, which there's a lot of you here, you do need to be familiar with how does it come up, future interests, how do they come up, how are they tested? They don't come up a ton, but they come up enough that you do need to have some familiarity with it. Okay, here are some subject specific tips. And these slides, if you are in our BarMD MBE free workshop, you will get this table. So these are things that people have a hard time with. And sometimes, but it comes up as a decoy often. And I don't know, Michael, that you can actually say that it hasn't come up in the MBEs because it would require everybody to know whether they got that right or wrong. It's just it's too hard to actually say that it is still totally testable and could come up. So here is a little table. It's just an example of something you might do to get everything sort of straight. Is you want to know the various motions, so MSJ, JMOL, RJMOL. So there's the standard, here's the timing, because you really oftentimes there is a timing issue. That is the timing of stuff comes up, the timing of motions comes up quite a lot on the Civ Pro MBEs. And then I just have a note here. This is just a notes category of, things that have come up, things that I've seen, that people have missed on an MBE. So you can fill this in as you like. So a judge can grant an MSJ sua sponte. They can totally do that. So if a JMOL is granted and a motion for new trial is brought up at the same time, the judge has to conditionally rule. This is in rule, I think it's 50. And if a JMOL is reversed, a new trial will occur automatically unless the appeals court indicates otherwise. So these are some little things that people don't always think about or don't always see, but that comes up in an MBE. So here's a couple of little Civ Pro tips. And then also motion for a new trial and motion seeking relief from judgment. So there's the standards. It depends on the specific grounds here. So the court will grant a motion for a new trial if one of these grounds exists. So if there's prejudicial error, if there's newly discovered evidence that could not reasonably have been discovered previously, there's excessive damages or inadequate damages, if there's prejudicial misconduct by the parties or the jurors or the witnesses, if there's prejudicial misconduct by anybody, or if the verdict's against a clear weight of the evidence. A really, really important thing though is knowing, okay, for the motion for a new trial, you have to know these grounds, know what it looks like for there to be prejudicial error, but you have to bring it within 28 days after entry of the judgment. But if a motion for relief from judgment, if they say it's 30 days after entry of judgment, then you're in this realm. And you have to say, okay, well, is one of the grounds present? So was there a mistake? Is there newly discovered evidence? Was there fraud by one of the parties? Has the judgment been declared void or the judgment been satisfied? And this, depending on the grounds, these have to be made within a reasonable time. And what that time is depends generally on the grounds. It's usually within about a year. So you have more time for a motion for relief from judgment. But they pit these two. They'll say, which motion should somebody file, or should they file an appeal? You also need to think about appeals and when can somebody file an appeal and all of that. So you want to know these two, plus how are these motions pitted against each other? So somebody asked for motions specifically. This is what I was thinking you might be interested in. And this PDF, the PDF of these slides will be posted. Yeah, knowing the time determines which motions. Yeah, it's super nuanced. And yeah, I put a lot of that detail in the book. I'll show you guys. I think it's more updated on my other computer, but I put whenever there is a tip that I have, I put it in a little box next to the rules. I'm watch out for this, watch out for this, watch out for this, for that, whatever that particular issue is being tested. And I do a lot of talking about how the rules sort of interact with one another. So I'm like, okay, you have this motion, but if there's been an appeal, think about this. If, you know, what all's going on. This is not the most updated version that's open on my laptop, but like, you know, here's joinder of claims, supplemental jurisdiction. So here's the rule, here's the exception, and then you go down to class actions. These are tips where I have taken like a fact pattern and extrapolated, taken a step back from the rules based on that. How do they generally test this issue? And like, in the way that I did this is looking at MBEs, but also looking at MEEs and how stuff comes up there, because there are issues that we have seen come up in an MEE, which is written by the same people that administer the MBE. So on the MEEs, it's like you can take those and sort of extract hypos, and you could see, I've seen MEEs and MBEs be basically identical. So I've gone through literally all the available material to then write all these tips and these rules. And I try to really break stuff down, number it, etc. This is the MBE. Yeah, this is the MBE book that I'm just giving you a little preview of. So you can see all of these various little issues. And I do examples and footnotes and all of that. So let me go back to the essay book and the MBE book are different. The essay book and the MBE, yeah, they're different. The MBE book goes deeper than the essay book. There is some overlap, obviously, in material, but the MBE book is really also like designed to be a little bit different and to like have the questions. It's really taking MBEs and making it like you can use the MBE, join it with like Adaptive Art or UWorld or whatever it is that you have, and like really make a full MBE course of study, which is my goal. Because again, structure. The MBE book is, I don't know exactly, it's like 350-ish pages. So if there's not a book just with tables like these, no. So there's also this, so a couple more tips. So if the call to question asks whether a motion for summary judgment will be granted, think about the underlying claim and consider whether the elements are met. That's just like kind of a basic rule. And sometimes something seems final, but a decision on a motion for summary judgment is not a final judgment for purposes of appeal. If they grant it, it can be, but if it's a denial, it's absolutely not. And impleader. So impleader only applies if the third party plaintiff, so the original defendant, is alleging that the third party defendant is also liable for indemnity or contribution. So if the third party plaintiff is found liable. So it's really just saying like if the original defendant brings in another party for indemnity or contribution, that's impleader. So you want to know the distinction between impleader, interpleader, and intervention, because those will be pitted against each other as well. So, and also they will do this too. They'll mention that the jurisdiction has abolished contribution, indemnity, joint several liability. So you cannot have impleader in those situations. That's another way they test, do you know what impleader is? They're going to do it by giving you that other rule, which is really tricky. Right? You haven't really thought about that. So this is really understanding like the way that they structure these questions. Some tips on torts. So half the torts questions are negligence, and figure out where in negligence you have issues. It's often in duty. So like I have a table of all of the like landowner duties, various landowner duties and issues that generally come up with those. Also, this is huge because this is why so many people are surprised. Like they'll be like, wow, I didn't do as well in torts as I thought I did. So one, if you get a score report because you found out that you didn't pass the bar, you will get on it. It will tell you how well you did compared to other people. So there's percentages next to it. That just tells you literally like you did better than 20% of people on torts, 50% of people on Civ Pro. But people generally do a bit better in torts than other subjects because torts is often a strong suit. So just because you didn't get didn't do better than a ton of people doesn't necessarily mean that you did terribly in that subject. So keep that in mind. But also the thing that makes torts questions actually more difficult is that often they don't tell you the cause of action. So you have to actually, like, you might be assuming that it's negligence, but it's actually intentional torts that they're looking for, but you're not even thinking intentional torts. So ask yourself, like when you go through those questions and you picked, an intentional tort answer, but it was really a negligence answer, why is that? And what makes it a better, one versus the other? So it's really, again, about understanding the questions, the way they're written, how they try to trick you. And then negligence. Even if a question asks you for the best defense, you want to run through the elements. So this is a huge thing. So there is like the best defense, people think of affirmative defenses, which is something like contributory negligence or assumption of risk. But just because it says best defense doesn't mean it's limited to solely affirmative defenses. So an affirmative defense is something that, like assumption of risk or contributory negligence, that is outside the elements. It's like something you can say, even if somebody proves a prima facie case, you have a valid defense. But the best defense is actually that an element isn't satisfied. So, that is a better defense than even assumption of risk because the case gets thrown out sooner. You always want to think the best defense is going to be the most efficient defense. This also comes up in Civ Pro too, like what's the best way to defeat a motion for summary judgment? It's the court denying it because the non-moving party needs to still conduct discovery, right? So people often say like, oh, there's a genuine issue, right? But we don't even get to whether there's a genuine issue if we say like, I need to just conduct discovery. That's more efficient because it's going to get kicked sooner without even getting to the merits of the motion. Also, res ipsa, people get thrown off on res ipsa a lot. This is something when I do tutoring, I'm constantly seeing like a pattern of people missing res ipsa. So there's tips on res ipsa, but one of them is if there is any sort of indication that the defendant behaved unreasonably or carelessly, you cannot have res ipsa as the answer. So because the defendant has to basically be totally clean for res ipsa. It's also knowing, the type, like it's usually brought with a particular type of motion. There's like a JMOL or an RJMOL, or yeah, it's usually one of those that somebody is bringing. And so you want to know, or they often say a motion for a directed verdict, which is just old phrasing for a JMOL. That's the other word I was trying to think of. So you want to know, okay, if you're dealing with a directed verdict, often it's going to be something dealing with res ipsa. And yes, sorry. I love this stuff. And when I get excited, I speak quickly. So with res ipsa, if there is a motion for a directed verdict, often what happens is, so if there's a motion for a directed verdict, somebody is looking to challenge the sufficiency of the evidence, and you have to really look at that. And often there will be something saying, plaintiff has provided this evidence, defendant has done nothing in response. And so people think, well, defendant did nothing in response, but defendant doesn't need to do anything if res ipsa applies. So it's getting used to really how they test all of these particular issues. So in all of that with the MBE book is laid out so that you review the black letter law, you see the tips, and then you see it in application with the questions immediately after you review the black letter law and the tips. And also, last little tip for torts is pay attention if the facts mention that the jurisdiction is a contributory negligence jurisdiction, because that generally will have an impact on the answer choice. So that's one other last little tip for torts. Contracts. So these are some common distinctions or frequently tested distinctions for UCC common law. And I have a table of more of these as well in the books, and tables on consideration, exceptions to consideration, etc. But modification. So when there is a modification, UCC, you don't need consideration. Common law does require consideration. You want to really look at that. And then also irrevocable offers. You do have to provide consideration if it's common law, but you don't need it if it's a merchant's firm offer. So no consideration is necessary to create a merchant's firm offer, which is irrevocable. So you want to really know and build your common law UCC distinctions and know how they come up, because it's really important. It's really important at the outset of any contracts question to like make a note, mark it up, UCC or common law, like which is it, so you remember that and write it down, because you're going to forget. And you're going to see there's often the two answer choices that are attractive. The answers that are attractive, one is going to be UCC and one is going to be common law. So, and it's tricky because a rule looks familiar. They'll both look familiar, but you have to remember it's UCC common law. A couple of questions on third-party bennies. So is a beneficiary intended or incidental? Remember, they don't have to actually name the person for them to be intended. There's a question that everybody misses. It deals with somebody buying a car. And so they say like, okay, I will pay the car person, whoever it is. So they don't have to name them specifically, but if that person, whoever it turns out to be, is referenced, they can be an intended beneficiary. And if they're intended, have their rights vested. Usually they vest, you want to know how do somebody's rights vest, so they become aware of it or they've relied on it. And if the intended beneficiary's rights have vested, could the original promisor have asserted any defense against the original promisee? You want to look for defenses. And there's an easy way to tell an intended third-party beneficiary from an assignee. So this is another thing you have to track that people don't often think of. They know the intended beneficiary rules, they know the assignee rules, but they don't think about distinguishing between the two. So an intended third-party beneficiary is either referenced in the contract or contemplated at the time the contract was formed. But an assignee appears totally after the contract is formed. So an assignee is not an intended third-party beneficiary. And somebody asked if I could go back to this last point in torts. It's just that if they, you always want to pay attention to if they say that it's a contributory negligence jurisdiction, pay attention to that and think to yourself, okay, if it's contributory negligence here, was the defendant contributorily negligent, and what impact does that have on the outcome? So I said this already, but start every single contracts question by making a note in the margin about whether the UCC or common law governs. So that's massively important to pay attention to and to keep in mind. And one thing is, like, you've got to take notes in the MBE course. I'm definitely going to be digging into questions and showing you how to diagram, how to really diagram efficiently and quickly. Like, I use shorthand methods to make it a lot easier for Civ Pro, property, contracts, what to pay attention to, because you just can't keep track of it all in your head when you're doing these questions in 1.8 minutes. And then also, if the contract at issue falls under the statute of frauds, make a note in the margin, like SOF. And if it's obvious that the statute of frauds is met, put a check mark next to it. So if you have a check mark next to the statute of frauds, you can eliminate an answer choice that suggests the contract is invalid due to failure to comply with the statute of frauds. And it's usually not going to be so simple. Like, there's a classic, I think it's property. I think it's tested within property, actually, but it's property contracts, where somebody is conveying an interest in land, and they're doing it like they're dying, they're on their deathbed. And so they call somebody and they say, can you transfer, like, I'm going to give you power of attorney. And as power of attorney, I want you to convey a piece of land. But you can't do that because the conveyance of the power of attorney was to transfer a piece of property, and that you needed it to be in writing. So it's like a step back from the statute of frauds. But so always be cautious no matter what when there's a telephone call. You always want to be cautious. So common law, know your standards, obviously, like, know all of your, I would make various tables for free speech, equal protection, substantive due process, all of the fundamental rights, what the standards are, etc. So, like, this is something in the class, you'll get a copy of this, and it's in the book, etc. too. So equal protection versus substantive due process. So on the essays, these overlap. And, like, generally, if you see a particular issue, you're often going to talk about, particularly in California, equal protection and substantive due process. They kind of go hand in hand. But on the MBEs, they're testing you really on just one. So it's equal protection if it distinguishes between or applies only to certain classes of people or entities, not entitles, or entities. So if it's college graduates, pregnant individuals, right? So if it's substantive due process, it applies to everyone and concerns a fundamental right. And the big trick here is often it doesn't discriminate against a protected class. It doesn't involve a fundamental right. But the only argument that might win is equal protection or substantive due process. So you want to, like, pick that. It's rational basis, probably going to lose, but that's often the correct answer. People have such a hard time selecting that because they're like, oh, well, that would lose. But it might be the only thing that can win. So that's a huge thing to look at. And you constantly pick equal protection when the correct is substantive due process, or vice versa. So you really want to look at that. It's this type of nitty-gritty detail. And, like, I do a ton of MBE tutoring. If anybody wants to talk about that, we can talk about that in a score review. But I do a ton of tutoring for the MBE where I actually go through and look at your correct and incorrect. Well, I look at your incorrect answers and compare it to correct. And I identify the patterns in what you as an individual are missing and why. So that's something, like, if you have a hard time sort of figuring out your MBEs, like, that's where I come in and can help with that. But I'm hoping to do a lot of that with the MBE course that I'm teaching to help people see that stuff. And then this is just a general tip. This is something that applies really to all MBEs. So there's these things called implied absolutes, and this happens a ton. So not to pick answers with an absolute, right? So it's something that says always or never. But some answers have an implied always or never. So, like, the statement hearsay is not admissible really means hearsay is never admissible. That's what that actually means. Like, often when you see an is not, that there's an implied never. Really means, is never. Or if it says a contract for a sale of goods over $500 is not in writing, isn't enforceable. That's not always true. There is exceptions to that statute of frauds. There are exceptions to that. You want to really watch out for that. And this last one, intentionally causing a harmful or offensive contact to another person is battery. There's an exception because what if you have the defensive consent? So it's not always the case. So you really want to look out for that. Yeah, you really want to look out for that. So look out for these implied absolutes. This is something that I point out to a lot of people when they're missing. This is something, like, I will often notice a pattern of somebody missing this before they do. Okay, so here's just a little bit on some of the products that are coming out. We do have a wait list for this book. So if you want to be notified when this book is released, we have a little sign up. So if you want to be on the wait list for the MBE book, you can sign up right there. But I'm super excited about it. It's been a massive labor of love. Digital copies coming out November 10th, and the hard copy will start shipping approximately 3 weeks later. And we'll keep you guys more apprised of that, but we will make it so that you can print out some of the initial assignments so that you can start doing that in hard copy. but it's all the black letter law you need, strategies, tips, charts, all of that type of stuff from like my years of going through. Like I've literally pulled apart every single MBE numerous times. I know them like the back of my hand. It also contains all of the 410 real MBE questions, all assigned with the black letter law. So you're really doing these like very targeted sets so that you can see the patterns. The book is designed to teach you the patterns. And then I teach you, okay, after you finish these first like 4, 5, 6 weeks of doing all the questions this way, then what do you start, how do you incorporate more MBEs into your study? Because it doesn't stop, obviously, with just these 410. I can't make the book printable. Well, there's a potential that I can, but it's incredibly, I'm going to try to do it that way. But yeah, we're going to explore that. But usually the way that we do it printable to make it not shareable, because just to protect my intellectual property, it's really tough. But yeah, it's going to be, as soon as we possibly can. And I'll show the book again. But yeah, there will be printed copies. So like we're printing it, binding it, doing all of that. So I don't want PDFs of my book floating around. So that's why I protect it. Sorry. So, and there'll be a rush on the printing. So let me just show, I know I can protect a PDF, but people then scan them and share them. And I'm aware of it. I'm in all the groups. Oh, I do see it. The MBE class. So that's what I want to talk about. So it's 8 classes, begins November 9th. It's going to be a $4.99 class, but we're doing it as an intro rate for $99. So let me give you all the link for that because it's a crazy good deal. I don't even know why I did that, to be honest, but here's the link for that. You should sign up for that because the price goes up. And even if like you haven't gotten results yet, if you want to buy it and then you're like, hey, I actually need to take it, you can get a refund. That's fine too if you want to get it for the lower price. So there's the link for that class there. I'm super excited about that class too. I'm really trying to make, my whole thing with bar prep is I do want to try to make passing the bar more accessible because oftentimes for MBE, it's like, I do try to make my stuff a bit more affordable and transparently priced than a lot of places. So, because I don't like it when stuff is not transparent. So yeah, so I'm trying to like really, if you can't afford to do tutoring, which a lot of people can't, I get it. Yeah, and the questions in the book are real questions. It's all of the most recently released questions. So 2017 questions, 2021 questions, it's all of those questions. So they're all real questions. So this class though is I'm super excited about. The price goes up November 1st. And these are recorded. The price is going up to $4.99. So it's a huge discount. I might do like a little bit of a stagger. It might go up to like $1.99. And after that, I'm not totally sure, honestly. They're recorded. You get access through the bar cycle. You get access through the bar exam cycle. And for any of my courses that you take, if you don't pass it, if you take it and then it turns out you don't pass the bar, you can access it again for free once. All right. So that's that class. We also have mastering essays, mastering the PTs. I'm going to talk about this stuff in the other free workshops that I have coming up. Make sure you sign up for those free workshops. I'm super excited about them. Yeah, we're going to like dig in. I'm going to try to keep them a little bit shorter. I know some of my workshops go really long because I try to really get into a lot of detail. But these classes, this is when the classes start. Mastering the essays starts 12/12. Mastering the PT starts 12/14. So definitely be on the lookout for those classes and for the free workshops this week. And then here's the date for the free workshops. No, California's not bypassing the bar exam. I mean, there's people that are pushing for that, but I don't think it's going to. The essay book. So the essay book, all of the essay books, we're doing a massive order. So they're all going to be shipping like end of November. It's just really it's all contingent on my printer. So I'm like a little bit ambiguous with the dates. So, but the essay book will be coming out, in print form in November. So which still leaves you 3 whole months, which is a lot of time. Then I have some questions. The UBE essay book is being released the week after. So that's being released, I think November 17th is when that comes out. I'm super excited. That one is such a labor of love. So that will be coming out. Louisa, did you have a question? Oh, yeah. And I have actually talked with Snoogoat, this person on Reddit, and I think I do want to do like a little workshop or do a little collab with them. We have to talk. We've like messaged a bit before, but I'm not sure. But yeah, that person, I don't know who that person actually is, but I just know their Reddit group and I find them entertaining. So yeah, I'm going to reach out and actually see about doing a little collab. Oh, okay, cool. The PT workshop that I'm doing this week is, it's good for California and it's good for everybody. So Olga, it would be good for you for sure. So I'm going to talk about, I think I'm going to pick I don't know if I'm going to take a California one or a UBE one yet. UBE is actually a lot trickier to do. Kathleen, how do I incorporate MBE minutia with the study schedule? It's just like, it's really just, it would be, you just add and like watch those videos on that date or join the class. And yeah, I do have bar prep courses for UBE also. If you want to set up a score review and talk about your scores and like what you can do to benefit, definitely reach out. I'll put the link for scheduling a call with me in the chat again. Here's that link. And the MBE course is 8 classes. It's a huge, like really good value. So the essay book is $149. If you want to add on the printed version, you just pay for the cost of the printing. It's going to be around $20 to $30 for like printing and shipping. Because my books are actually printed in color because I do so much color coding. So the MBE book is not. But Grace, I do like structure. I do have like a daily study schedule if you're in my full courses. Yeah, the first MBE minutia class is $11.29. Yeah, and early intervention is also a super good value. If people are studying early, like I've been doing an early intervention, like an early bar prep class. That's also a really good value. I go over essays and MBEs, like MBE tips each week, basically. So it's a really, really good class. Let's see. The MBE course starts November 29th, and each class is 2 hours. The book is not included with the course. So the MBE course, because they're covering different things, like if they're really covering 2 different things. Hey, well, you should meet with me. Somebody asked, at what point do I recommend using a tutor instead of just enrolling in a bar prep course? That's something you should really like that's something I would say, like, it's not a generic answer. It really depends. But I mean, I do have an answer for that. It's if you have studied on your own or done a bar prep course and not seen a dramatic increase, and then that means that one of the issues may be that you're not good at a self-assessment. So which is a really big common thing, is people aren't often very good at knowing what their weaknesses are or seeing what their weaknesses are. People often tell me it's one thing and I'm like, no, it's actually this other thing. So if you feel like that's you, then that's where a tutor comes in. But you should always like interview people. Your tutor should have access to a ton of materials, be able to help you, not just like they should have answers for essay questions and all of that, give you like a packet of essay materials, PT materials, et cetera, that you can use also. So it's not just, MBEs are a little bit trickier, but thank you so much for joining me. I've had a really good time. I love doing this stuff. And I'm going to teach all of the MBE classes live too. So I will teach all of those classes. I love doing this stuff. I absolutely love teaching. So I really hope that a lot of you join that. Sign up soon because that price is going to go up. It's such a good deal. It also includes 200 questions. So a really, really good value. So yeah, if anybody has any questions, feel free to reach out. You can always shoot us an email. And all of the courses, everything I do is always recorded. So we always post videos within about 24 hours. So yeah, thank you so much, everybody. I really, look forward to hopefully working with all of you and some of you. And yeah, if you need anything, feel free to reach out. Thanks, everybody. Bye.